Thank you for being part of our webinar. This is Greg Brown. I am the Senior Vice President for Government Affairs here at NAA. Joining me today is Nicole Upano. She's NAA's Manager of Government Affairs. And you are participating in a webinar on two trending issues before the apartment industry right now, companion animals and source of income protection. For the next 30 to 45 minutes, Nicole and I are going to brief you on these two issues, give you a little bit of the basics of each one, explain some of the key concerns for the industry, talk about what NAA is doing to address these issues, and then finally discuss a bit about the outlook for each. It's important for me to say to you that none of what we're sharing today should be considered legal advice. This is purely educational in our effort to explain the law to you. You should always consult your attorney on these issues. Couple of housekeeping items. First of all, we are recording this webinar, and it's going to be available on AEX by the end of the week. So if you have colleagues that were not unable to participate today but want to watch, or excuse me, listen to the webinar, they can do so. We're going to have lots of time for questions at the end of our formal remarks here. You'll see a box to the right of your screen where you can type questions for either Nicole or myself. If you have a question that comes up during our presentation, feel free to type that question, and then we won't address it at that point, but we'll definitely get to it at the end. So go ahead and do that. You're going to get a survey from NAA following this webinar. Please complete that for us. It's both for you to tell us how we did on the webinar, but also to help tell us how these issues impact your business specifically, which is very helpful for us. It's pretty important information, and I do appreciate you taking the time to complete that. So look for that either today, this afternoon, or tomorrow. Now, before we get started, I want to take a quick second to recognize our sponsor. Our sponsor for today's webinar is Zillow. When property managers and owners advertise rental listings on the Zillow rental network, your listings will appear on Zillow, Trulia, HotPads, and several others. The Zillow rental network attracts 50% more rental shoppers than their nearest competitors. In a recent customer survey, Zillow had the highest brand awareness among rental websites. To gain access to their large consumer audience, they offer marketing solutions for landlords and property managers of all sizes. Postlets is a free manual listing creation tool for those with single-family homes and multifamily properties with fewer than 50 units. Go to postlets.com to create a free account. If you manage several properties and want to send listings to the Zillow rental network on a listing feed from your property management software, contact rentalfeeds@zillow.com to find out how to get started on that. And finally, the pay-for-performance solution is for property managers of large multifamily properties with 50-plus units that want to advertise on the Zillow rental network. Contact multifamily@zillow.com to find the solution that works best for you. And again, a very hearty thanks to Zillow for sponsoring our webinar today. Now with that, I'm going to turn it over to Nicole to tell you about our first issue today, companion animals. Nicole.
Thanks, Greg. Good afternoon, everyone. As Greg may have mentioned, I am the state and local manager for the association that covers fair housing issues. I wanted to start off with a brief overview of the terminologies used in this area. We had several questions come in prior to today's call, and I wanted to cover that material in my comments today. So to start off, a companion animal is never considered a pet. To give some background on terms, an assistance animal is the umbrella term for an animal that provides assistance to a person with a disability. This includes both service animals and companion animals. So service animals are specially trained, in other words, to guide individuals who are blind, alert individuals who are deaf or hard of hearing, provide rescue assistance, they can pull a wheelchair, and alert an individual of an impending seizure. While a companion animal is not required to be trained. For example, a companion animal might provide emotional support to persons with disabilities. So think of those two terms in the same vein, companion animal and emotional support animal. A therapy animal is another term used. They provide people with therapeutic contact to improve their physical, social, emotional, and/or cognitive functioning. So an assistance animal, service animal, companion animal, emotional support animal, these animals are not pets and as such are not bound by the same restrictions that pets are. Think of it in terms of a wheelchair. These animals are meant to assist an individual with their disability. So if a tenant requests a reasonable accommodation for one, you may impose you may be required to make an exception to one or more rules or policies, and you cannot impose different terms and conditions on that resident that do not apply to other residents. They cannot be subject to a no pets policy, and a housing provider cannot charge a pet fee, require a pet deposit, or a pet addendum for these types of animals. I have heard that you can require a general animal addendum that requires the resident to be responsible for damages caused by the pet, agrees that the animal won't disturb others, agrees you'll pick up after your pet, and observe all leash laws in accordance with local health laws, and requires the animal to be properly vaccinated. The biggest takeaway here is that you be very careful in the terminology you use in your policies, lease documents, etc. So we'll get into the details more later in my presentation. Next slide. Here are the relevant laws and regulations that govern companion animals or emotional support animals. And here in this webinar, we'll focus our attention on HUD Guidance. HUD Guidance is intended to give landlords practical guidance on this issue. And at the moment, there is a lack of clarity in the guidance that allows for abuse of the law. But first, I just want to give you the basics of reasonable accommodation specific to companion animals and outline the exceptions. And just a reminder, this information is not to be taken as legal advice. We're reiterating what the law says and what HUD's interpretation of the law is. So after receiving a request for a reasonable accommodation for an emotional support animal, the housing provider must consider the following. Does the person seeking to use and live with the animal have a disability, as it's defined under the law? Do they suffer from a physical or mental impairment that substantially limits one or more major life activities? And question 2, does the person making the request have a disability-related need for an assistance animal? In other words, does the animal work, provide assistance, perform tasks or services for the benefit of a person with a disability, or provide emotional support that alleviates one or more of the identified symptoms or effects of a person's existing disability? Now, housing providers may ask individuals who have disabilities that are not readily apparent or known to the provider to submit reliable documentation of a disability and their disability-related need for the assistance animal. If the disability is readily apparent or known, but the disability-related need for the assistance animal is not, the housing provider may ask the individual to provide documentation of the disability-related need for the assistance animal. So for example, the housing provider may ask persons who are seeking a reasonable accommodation for an assistance animal that provides emotional support to provide documentation from a physician, psychiatrist, social worker, or other mental health professional that the animal provides emotional support that alleviates one or more identified symptoms or effects of an existing disability. And again, I want to caution you against asking about the particulars of the person's disability. It's important to verify in the documentation that the person has a disability as defined by the law, and that there is a nexus between the person's disability and the need for the animal. Next slide. So there are very few limited exceptions. So if the answer is yes to both the questions in the previous slide, a housing provider is required to modify or provide an exception to a no pets rule or policy to permit a person with a disability to live with and use an assistance animal or animals in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial and administrative burden or would fundamentally alter the nature of the housing provider's services. There are two other limited exceptions that would be valid rationales for denying a request for a companion animal. That the specific assistance animal in question poses a direct threat to the health and safety of others, or the specific assistance animal in question would cause substantial physical damage to the property of others. And there's one caveat that it cannot be reduced or eliminated by another reasonable accommodation. So one question I received prior to today's call was a situation where an owner has, for financial reasons, chosen insurance coverage that does not include animals of any kind. So for that reason, they've chosen to establish a no pets policy. The owner asked, as a concession to a request for a companion animal, can the owner require the resident to provide proof of insurance coverage to cover the potential liability for the animal? And to answer this question, you cannot require the resident to have coverage for the animal. You're imposing different terms and conditions on the resident that aren't imposed on others in the community, and that is a big no-no. With that said, the owner did make a good case for the first exception in their email that I received, that it would have an undue financial burden to approve the request for the animal. So, excuse me, irrespective of what I said today, I would check with a fair housing local attorney on this. There's so many scenarios we could come up with here, and I can tell you what the law says, but a local attorney would know if there's case law leaning one way or the other on this in a particular jurisdiction. Next slide. So we've identified several concerns for landlords that typically fit within one of these four categories: loose documentation requirements, requests for multiple animals, the inability to decline dangerous breeds, and mandated community-wide access for all emotional support animals. And so we'll start with loose documentation requirements. So right now, the law allows for the use of these websites. They are acceptable for verification purposes. And our job, NAA's job, is to bring these concerns to HUD for further clarification, but at this point, they are acceptable for verification purposes. So typically, tenants will use these online resources to unnecessarily certify or register their emotional support animal. And the biggest takeaway here is there's no such thing as a certified companion animal. They're not required to be trained or registered. And oftentimes, these certifications are used to attempt to intimidate uninformed landlords. Next slide. Another issue that we've seen from members is that in addition to these online registries, often tenants will use online resources that provide a form letter for a price. So the tenant fills out a questionnaire or Skypes with a medical or mental health professional that they have no prior relationship with. They pay a fee, and in exchange, they get a form letter and instructions on submitting the request to their landlord. And this is also acceptable verification at this point. There's a lack of clarity in the law that allows for this, and like I've said before, NAA's job is to bring this to the attention of HUD and go from there. And also, it's important to note that when you do request verification, you need to find a nexus between the person's disability and the disability-related need for the animal. So that's important to look at the verification for that purpose. Right, and another concern we've heard from owners about is requests for multiple animals. So a tenant they are allowed to and may request or require more than one assistance animal. A good example of this is a veteran who may need a service animal for mobility purposes and a companion animal for emotional support. And if you note here, each animal serves a particular distinct purpose related to the person's disability. So for the purposes of documentation, remember, what is the nexus between the tenant's disability and the disability-related need for each animal? Next slide. So in regard to dangerous breeds or dangerous types of animals, the law is clear. Breed, size, and weight limitations may not be applied to an assistance animal. And a determination that an assistance animal poses a direct threat must be made on a case-by-case basis, relying on objective evidence about the specific animal's actual conduct and not on mere speculation or fear. So the owner must perform an individual assessment on the animal. It can't just be because it's a pit bull. It needs to be based on that specific animal's past behavior. Has the dog ever bitten anyone? Have there been past police calls or calls to animal control related to the particular animal? And there's one exception to this rule. HUD has released guidance specifically related to dangerous breeds. According to HUD, the law says that an accommodation is unreasonable if it imposes an undue financial and administrative burden on a housing provider's operations. If a housing provider's insurance carrier would cancel, substantially increase the cost of the policy, or adversely change the policy terms because of the presence of a certain breed of dog or certain animal, HUD would find this imposes an undue financial and administrative burden on the housing provider. And with that said, practically speaking, I've heard from owners and their attorneys that They're not comfortable relying on this exception, but it is out there, and it puts the burden on the insurance company. And the last concern that we often hear about from owners is providing access to the animal to all areas of the community. And for this concern, the law is clear as well, where the answers to questions 1 and 2 are yes. In the previous slide, the Fair Housing Act and Section 504 require the housing provider to modify or provide an exception to a no pets policy or rule to permit a person with a disability to live with and use the animal or animals in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial and administrative burden or would fundamentally alter the nature of the housing provider's services. Next slide. So now what? So as I've said, NAA has heard from members on the preceding issues, and we're working on a few things to allay these concerns and bring clarity to owners when it comes to requests for companion animals. We've consistently heard from members that companion animal or emotional support animals are an issue. And in response to this, we've organized a group of NAA members, attorneys with expertise on this issue, and affiliate staff to come up with possible solutions or ways to address these concerns. So we've identified the issues of most concern, and those are the 4 issues that we listed on the previous slide. And the working group thinks that the documentation issue has the most promise. So we're engaging HUD in discussions and focusing our attention on the documentation piece. In addition to connecting with HUD on this issue, we're working on some informational materials to provide members with more clarity. So at this time, Greg and I are working with the working group on a policy statement, some NAA guidance on this issue, and we'll be pushing out this information to members in a future article in Units and possibly a webinar. And so where do we go from here on this issue? Where do we think it'll go from here? So on the one hand, we're looking to HUD to make formal changes, whether that's in formal comments or updated guidance. And while we continue these ongoing discussions, we know of ongoing conciliation discussions that may yield some results more quickly in the form of approved forms and et cetera, and we'll keep you posted on any developments in this area as well. So in closing, my contact info and Greg's will appear at the end of the presentation. Please feel free to contact me if you have any questions. I'm happy to provide HUD's guidance documents that I referenced in my comments here. If you wanted to read them in full, I think it could answer many of the additional questions you may have. And if you or someone you know is currently involved in a situation involving a companion animal, please do let us know. Legislators want to hear from you. In other words, what are the unintended consequences of the laws that they pass and how they affect housing providers in practice. They really want to know that information. So also I'm working with Greg and the Emotional Support Working Group to come up with guidance on this issue. We hope to have a frequently asked questions document or a quick guide basically for owners and managers. So let us know what specific questions you want answers to, and that'll be part of the survey that you'll receive at the end. And with that, I'll turn things over to Greg. Thanks.
Thank you, Nicole. Remember, everyone, if you have questions about Nicole's presentation, you can enter those in that question box to the right of your screen now, and then when we get to the question portion of the webinar, we'll refer to those. So now we're going to turn to a different issue, source of income protection. This is not necessarily a new issue, but it is certainly one that is trending upwards recently. As you know, federal fair housing laws protect a discrete set of classes from discrimination. However, states and localities have the ability to add to this list of classes with others of their own determination. And source of income is one of those additional classes. And why do state and local governments do this? Well, in addition to discrimination goals they might have or preventing discrimination in their view, local governments are also dealing with a continuing affordability crisis at the local level, a growing gap between wages and the cost of living, and unfortunately not enough supply of multifamily and affordable housing. So all of these factors contribute to a growing focus on source of income protection proposals. So let's define some terms to start. There are variations on the exact definition of a source of income depending on where you are, but there's sort of some general consensus that is reflected in this note from the Fair Housing Law Project, which defines source of income as a legal, verifiable income paid directly to the tenant or his or her representative, such as the payee. Some examples include Social Security, supplemental security income, AFDC, unemployment insurance, veterans benefits, pensions, wages. I would add alimony, child support, other sources of income like that to this list. So let's move on to look at an example of a local ordinance. So in the District of Columbia, this reflects what the ordinance is in the District of Columbia. The first paragraph lays out the various protected classes that exist under local DC law, and you can see it's a fairly lengthy list. I've highlighted and bolded source of income, so you can see that that is also part of what is protected in the District of Columbia. As I noted earlier, federal fair housing laws do not include source of income as a protected class, but they also do not preempt state and local governments from passing their own laws to prohibit an owner from declining a prospective tenant because they are paying with a Section 8 voucher. The last point is important. Source of income protection laws that include Section 8 do not mandate that you accept an individual because they have a voucher. It just means that you can't decline a prospective resident on the basis that they have the voucher itself. Now, there are lots of variations to this theme. Again, every state and locality does a little bit differently. For example, there are 3 cities in California that have varying ordinances. In East Palo Alto, they ban all source of income discrimination, including the definition of source of income, is any participation in rental assistance programs or housing subsidy programs. In Corte Madera, hopefully I'm pronouncing that right for our Californians on the phone, landlords are required to accept Section 8 vouchers only from existing tenants who qualify for Section 8 after moving into a unit. In Woodland, California, discrimination against Section 8 voucher holders is prohibited only as it relates to housing developments with affordability restrictions. So you can see there are some variations on a theme across different localities, even within the same state. Again, this slide shows both the protected classes in DC and the specific language they use to make sure that Section 8 is defined as a source of income. So what are some of the concerns that landlords have as it relates to this issue? Well, I'm sure that some of you on the call probably already participate in the Section 8 program. You accept vouchers, that is. So you're probably aware of what that participation brings when you participate in the program. Now, in addition to increased certainty of getting paid, since a voucher has the full faith and credit of the federal government behind it, there are some potential challenges that come with participating in Section 8. You can go through delays in inspections. Before a Section 8 voucher holder enters a unit, that unit has to be inspected. Sometimes those inspections can take weeks or in some cases even months, during which time you have to keep that unit open, meaning you can't rent it to someone else, which means you lose revenue and the unit sits empty when it doesn't need to. There are operational limitations on what you can and can't do in regards to evictions and other things when it comes to a Section 8 voucher holder. There's a lot of paperwork that comes with participating in the Section 8 program. There is a lease addendum which basically trumps all items in your standard lease. So when you accept a voucher holder, you have to accept the addendum to your lease, and that addendum is what's going to drive your relationship with that tenant. And then finally, sometimes there can be delays in payment. This is more determined by the local public housing authority. Some are more sophisticated than others, are better able to process payments more quickly. Others are not, and sometimes landlords can be waiting to get their payment. Now, as I said earlier, many of you probably already participate in this program, and the situation is that many in our industry have learned to work quite effectively with Section 8, even with all of these hurdles, but they do so by their own free choice. The program is voluntary, and Congress intended it to be voluntary. So in our view, mandating that someone bear the administrative burden of the program is unfair and against that intent of Congress. So just to give you a sense of the scope of this, let's look at how broadly source of income protection ordinances are across the country. This map gives you a sense of the scope of source of income protection. Those states in yellow have some version of a statewide source of income protection law. Some of these laws include Section 8, some of them specifically exclude Section 8, but they have some source of income protection law. The states in red do not have a statewide source of income protection law, but have localities that have such protections. And then I've marked 2 localities specifically just to draw your attention with the big targets on them. And those are examples of our two most recent examples of source of income protection ordinances that have been put in place. One is Austin, Texas, and the other is Santa Monica, California. So now what do we do that we have all this information and we kind of know the lay of the land? Well, our response has been on a number of different fronts. First, these ordinances have to be fought individually on a state and local level, and we'll get a little bit more into the limitations of the federal role here, but We've had a couple of notable successes already in this effort to stop these ordinances that are trying to be imposed at the state and local level. In Texas, the legislature recently passed a state law originated by the Texas Apartment Association, preempting any local government from implementing an ordinance that prohibits landlords from declining a prospective tenant on the basis of their Section 8 voucher. That legislation also overturns the Austin ordinance, which had been the law in the city of Austin for several months leading up to this legislation passing. In Indiana, the state affiliate there as well, the Indiana Apartment Association, took the same approach and was also successful in securing a preemption law against Section 8 mandates. So those are two big cases where, working at the state level, apartment associations were able to stop local ordinances across the state from being implemented. The second tack that we have taken is to try to secure, push HUD for some clarification or support for the voluntary nature of Section 8. We did this through some comments and guidance recommendations that we submitted as part of HUD's recent disparate impact rule. But unfortunately, we have not been successful at this point to get that kind of support from HUD. And in fact, there have been two fair housing settlement agreements that have been signed between the federal government and a city or county in the country, specifically Dallas, Texas, and Westchester County, New York, that actually included requirements that those localities consider source of income protection ordinances. In the case of Dallas, it doesn't say they have to have one. It says that they have to consider one at the city level. Now, what the question in the air for us right now is, what is the passage of the state legislation in Texas going to do to Dallas's requirement that it consider source of income protection ordinances? Time will only tell on that. We've also been alerting members of Congress to sort of this situation and the growing nature of this issue, and trying to recruit some allies where we can. Almost to a person, the members of Congress that we've spoken to have agreed that the program is voluntary. It was intended to be that way, and it's disappointing that it's being turned into a mandatory program. They're not so sure how we deal with that at the federal level, certainly, but they do agree that it's a problem, that this is the tack that's being taken with Section 8. And perhaps most importantly, what we've been trying to do is educate affiliates and the industry more broadly to get ahead of proposals. I think what you saw with the success in Indiana was they got ahead of any local ordinance being implemented. Austin happened so quickly that the state of Texas said they were in the only position they could be, which was to react, and their state legislature wasn't in session, so they had some limitations placed upon them. But in Indiana's case, they saw the writing on the wall, they got ahead of the issue at the state level, and they managed to head off any local ordinances. And that's really what our goal is, to make sure affiliates and members are educated and they can get out front of these things. It's much easier to stop something from happening than to try to roll back something that is that's already in place. And I think if you asked any of the Texans that worked on their state legislation, worked so hard on that, they would tell you that that very thing, that the effort it took to roll that back was probably a lot more than it would have taken to stop it up front, which was very difficult. So what's the outlook? Well, the outlook is that the fiscal constraints that I mentioned earlier on state and local governments are still here. They don't have a lot of extra resources to put towards affordable housing. They still deal with jobs are being created, but the wages are not necessarily keeping pace with the cost of living. So they still have that affordability issue. Those challenges are continuing to grow. In fact, you have a lack of supply of affordable housing, dragging wages. These things contribute to just not enough affordable housing for people to access. And when you're in that situation where you don't have resources to put towards something like putting money on the table to incentivize more development, you start to look at more quote-unquote free options, which mandates are free in the sense that you don't have to put any money out. You just mandate that someone has to take on a certain behavior. In this case, you're telling landlords that they have to accept Section 8 voucher holders. We're even seeing this trend in some fairly surprising places. There are some states around the country that tend to lean more conservative, and it has been surprising that these ordinances have come up. I think that may be just a function of the situation in those local cities in terms of their own affordability issues or other problems they're trying to deal with. So, but the point is that it's a growing trend, and it's something that we really need to get out ahead of if we're going to stop these sorts of mandates from being put in place. So with that, that completes the formal presentation part of our program from Nicole and I. I see we have a number of questions already teed up, so I'm going to bring those up so we can see them, and we'll do our best to answer these. And if we can't answer them, then we'll follow up with the individual questioner and get you some more information. This first question, I can't see all of it. It looks like the question is trying to get at the type of animal that someone can have as far as an emotional support animal, Nicole. Even snakes, I guess. The questioner is responding to the visual that had a snake up there. I guess the question would be, are there any limitations on the kind of animal that someone can have as a companion or emotional support animal?
Sure. Thanks, Greg. And thanks, Nancy, for your question. I would say here for this question, there are, as I said in my comments, there are a few limited exceptions. And if we're talking about poisonous snakes, that would fall under the exception for animals that pose a direct risk or threat to the health and safety of others on the property. So there are a few limited exceptions that that you can seek protection under, and I would stress taking a look at those.
Our next question is just in regards to emailing the PowerPoint. The PowerPoint will be available after this program, so yes, you'll be able to get access to this after we're finished here today if you like the slides. Okay, our next question from Helen is, if HUD says you can ask for medical provider information, how are the online service registries acceptable forms of verification?
So, thanks, Helen. So for the question here, documentation does not need to come from a medical provider. It can come from a medical professional, a mental health professional, a social worker, and other mental health professional is not a defined term. So I've heard from fair housing investigators that you could get your reverend to send in documentation for you, and that is technically acceptable.
So it's the lack of parameters that really is causing the issue for us.
Yes, yes, it is.
Okay, Richard has a question. Is it common practice to DNA test animals for tracking reasons?
I have not heard of DNA testing. What I've typically heard is looking into the prior history of the animal as far as police calls, calls to animal control, and that sort of thing. So, no, I have not heard of that, no.
This next question from Melissa is, we do not allow dogs at the property I manage. Other residents come in and ask why they can have a dog. What is the best way to answer this? I'm assuming that Melissa's referencing another resident comes in and sees someone with a companion animal, for example, and says, why can't they have a dog? How is the best way for Melissa to answer that question?
You know, that's a good question. You can't really give any information on their disability or anything or the reasons why they are allowed to, but just that you had, I guess, a reasonable accommodation request for that particular animal.
Melissa, I think a good thing for you to do is consult your attorney on that to get really specific about the kind of language you and your staff should be using. It's always preferable to have someone an attorney clear that so that you're saying exactly what's appropriate for that situation. What are the current recommendations regarding charging for damages caused by a companion animal?
So damages for a companion animal, those come out of the person's security deposit. You cannot request an additional animal deposit or pet deposit for that animal. Any damages they cause must come out of their security deposit.
Next question from Mark is, can we ask for a doctor's letter to validate the emotional support animal or service animal?
And as I've said, it does not have to be a medical professional that provides documentation for the particular animal. So you cannot.
So you can ask for documentation, but again, it's the definition of who a mental health professional is so broad it could be from anybody.
Yes, and the caveat there as well is, I guess for emotional support, it depends on if the disability is readily apparent, but I guess it wouldn't necessarily be for an emotional support animal.
Next question from Sandra is there somewhere you'll definitely have access to the slides after the program, Sandra. From Nadia, if we have an animal addendum that says a deposit is required for possible damages, can we charge a deposit for emotional support animals because we have not called them a pet, or will we only be able to charge for possible damages after they have moved out?
I've been told by fair housing investigators that you cannot charge an additional deposit for an assistance animal. It must come out of their security deposit.
This question from Danielle. As owners, how can we protect ourselves from being overwhelmed with emotional support animals? And two, How can we justify having a no pet policy and allowing emotional support animals even though emotional support animals are not considered pets? It just encourages individuals from claiming their pet is an emotional support animal.
I think it's important to note here that that if you have a form or something of the like, or a policy, that you make sure to find the nexus between the person's disability and their disability-related need for the animal. So if they already have a pet and now they're saying, now I have a disability and now I have a disability-related need for that animal, it's sort of going backwards a bit. Like if someone got a puppy and now they say that they need, that it's an emotional support animal. It's important to find out that there is a nexus between their disability and the disability-related need for the animal.
This question from Sandra, do we have to take direct deposit from Section 8 or can we request a check? Sandra, I don't know the answer to that. That would be a question for your local public housing authority, and different housing authorities, I would bet, have different capacities for doing things like direct deposit or a hard check. You'd have to talk with them about that. If some tenants are allergic to animals, how are their rights protected? Another question from Danielle. Good question.
That is a good question. If a resident asks for a emotional support animal, I think that this is so specific you'd have to ask an attorney, but I think that if someone asks for an emotional support animal in a no pets building, you can't move them to a pets building. You have to allow them to have that animal in their current unit. And so it would probably be a situation where you'd have to move the other resident.
Again, a good question for your attorney. Companion animals, this question is in regards to companion animals in common areas. Tenants share a back patio area in the rear of a duplex. Tenant A is allergic to cats and doesn't want cat in the common area. Tenant A simply hates cats. Tenant B is an owner of a companion cat and wants to enjoy shared patio with his animal. Can I restrict cat to inside Tenant B's unit only, or am I required or require the animal to be leashed when in common areas? Sort of gets back to the access to all areas question.
Good question. So anywhere that the person is allowed to go, the animal is allowed to go. So again, that's a question of you might have to move the person who is allergic to cats. And as far as leashing the animal, if you're requiring all the animals on the property to be leashed, you can require that the animal be on a leash in the common area, I believe. But that's an important question that I would consult a local attorney about.
In Los Angeles, there was legislation to allow 5 pets per apartment. This would allow 20 animals in a 4-unit building. Is there any effort to counteract this legislation? Good question, and that is an incredible situation. I can't imagine. What I would do is refer, Danielle, I'd refer you to the Apartment Association of Greater Los Angeles. They'd be more familiar with what's been done to work on that legislation. Chad has a question about companion animals. What about requiring tenant belongings insurance for all tenants that includes animals, even when the tenant has no animal? So I guess Chad's asking, can you require insurance of all tenants? It would seem to be as a way of getting insurance for people that have companion animals. So basically everybody has to have insurance, separate and apart from the animal piece.
Well, I have been told that you cannot require different terms and conditions of the person with a disability from others in the community. And yes, technically that would be true, but I would consult a local attorney. Because also if you're making it more difficult in any way for the disabled person to have to get their reasonable accommodation, that's also a big no-no. You could get dinged for that as well. Even if you're trying to apply it to all of the residents, you really should consult a local attorney.
Next question from Nancy is, what about unemployment as income? It would all depend on the local ordinance or the state ordinance, Nancy. Each one of them will most likely list the different sources that count as income. So certainly unemployment could be considered that, depending on what jurisdiction you're in. Where can we view the limited exceptions? I think Nicole referenced the guidance, the HUD guidance earlier, which really goes through all of this in fine detail. You can find that on our website. And so if you want to get a good look at that, please check our website out, the Government Affairs section of our website, or you can contact Nicole and I directly and we'll email it to you. Would food stamps be considered a source of income? Again, it would depend on the local jurisdiction's definition. And you'd want to consult the local jurisdiction's definition for source of income to see. From Rich, what is the consequence to saying no to someone with a therapy animal? What can they do to me if I say no pets, no animals, period? I'm sure they can sue, but how and for what?
Well, you would be subject to a fair housing discrimination claim, and there are a number of ways, including, making you pay amounts of money, and it wouldn't large amounts of money, and it wouldn't just be a situation where you would have to honor the animal. They could require you to pay a fine, and that fine sometimes goes to more testing or just to the they're called FAPs, I believe. Just for more education for the FAP, they can require you to pay a fine or some amount of money for that reason. So you would be subject to a fair housing claim.
This one from Casey. I had a request for a companion animal from a resident. On the request for modification form, the tenant answered no to the question of, are you disabled? Am I required to check with the medical provider as the tenant indicates they aren't disabled or handicapped? That's interesting.
Yeah, that's an interesting question, Casey, but there are two important questions here. Are you disabled as defined under the law? And if you are disabled, what is the disability-related need for the animal? So if they are not disabled, then they cannot seek relief.
So they cannot ask for a reasonable accommodation if they're saying they're not disabled.
Right.
Yeah. Jennifer has a question. Can we request the history on the dog? And I think the answer to that would be yes.
Yes, you can request history on the dog. I again would consult a local attorney if you're going to have a list of the things that you are going to request from the person regarding their animal, just to make sure that, again, you can get dinged for making it too difficult for someone to get their companion animal.
Ruth has a question about any idea where we can get additional information from HUD. Again, the guidance from HUD is on our website and whole sorts of other information related to this particular issue. You can go to HUD's website directly. The fair housing section of HUD's website is pretty easy to find, and they'll have information on this and a whole lot more as it relates to fair housing. Rich has a follow-up question. Can you refuse to accept their bogus documentation? I think the problem that we have is that technically there's no bogus documentation right now, since the rule is so broad, the guidance is so broad, and the rules are so broad as to allow essentially anything to count as documentation. That's part of our goal with our advocacy efforts here, just to have a quick aside, is to try to narrow the parameters on the documentation to allow you all to have a more confidence that what you're being given is actually legitimate, a legitimate bona fide mental health professional that's giving this information, or at least has a bona fide relationship with the person who has the disability. Let's see. Emotional support, this is from Nadia. Do emotional support animals have to be registered with the city, or will vet records on the animal and a valid medical reason be enough to accept that animal?
I don't believe that an emotional support animal needs to be on any sort of registry. As far as vet records and a valid medical reason. So basically you need documentation verifying that they have a disability and they have a disability-related need related to their disability for the animal. So
this kind of gets back to your slide about people thinking they have to certifications for the animal. And remember that the animal doesn't need to be certified. There's nothing related to the animal. It's only related to the disability of the individual who's seeking the reasonable accommodation.
Yes.
Okay. Can the security deposit be raised?
If you're imposing different terms and conditions on this disabled person than you are of other people, no.
If we only allow small animals on top floors, will we be able to allow large animals on top floors if they are emotional support animals?
As I've said, whether it's a no pets building, whether it's the size of the animal, if the reasonable accommodation is to request an animal in their current unit, if you did all the documentation, if you checked all of their documentation, you may be required to allow a large dog on a top floor if they are already currently in that top floor unit.
Robin has a question about liability on the part of the social worker or mental health worker who is endorsing the companion animal. Say I endorse the animal as the tenant's therapist and the animal injures someone. Is there liability there? That's a question for an attorney to figure out. It all depends on the facts and circumstances and a whole lot of other things. One would think logically the answer would be yes, but that's not something that we can answer here, and you definitely want to talk to an attorney about that. The law doesn't place any sort of liability. If that's your question, the law places no liability on anybody who provides this documentation, so it doesn't follow from there. It could follow from somewhere else, but we don't know the answer to that one. What about the rights of the allergic tenant related to their use of the common areas where the animals are allowed? I think we talked about this a little bit before. This question from Charles: if unable to move the person who is allergic, i.e. only one building, would not this impose a health hazard to the allergic person?
That's a good question, and I would consult a local attorney on that specific situation.
Yeah, that's a very good specific scenario, but you definitely want to talk to an attorney about that one. Can you make a requirement that the tenant be with the animal in the common areas or on the tenant's deck or patio? Interesting. I haven't heard that question before.
I haven't heard that question before either, but I believe so. If you are requiring that everyone on the property leash their pet and be in control of their pet, then that is not an unreasonable requirement.
So say, what if you had that requirement, but like I have a closed patio that no one else can access, and I put my dog out there just to do their business or hang out, and I'm inside. I can't ask the person with the emotional support animal to always be with their dog in that same situation, right? Because I don't require all tenants to do that.
Yeah.
Okay.
Yeah.
Charlene, how long am I required to hold a vacant unit for a potential tenant with a service animal while they're trying to obtain documentation for verification of the disability-related need for the service animal if I have other qualified tenants to choose from? So I'm assuming she means someone comes in to rent a unit, they don't have their documentation yet for their pet, and therefore they can't move in. How long does she have to hold a unit vacant for them, or is she? Would she be required to hold a vacant unit for them?
I don't know that there's any amount of time that you are required to hold a vacant unit. It's really a matter of, I think if it came down to if you had a fair housing claim on this, was it reasonable or not? How long did you leave the unit open for, etc.? I think that's a question for an attorney.
This is a question from Roy. It says that in Kentucky, the Kentucky law states that as a landlord, I am liable for that pet on that property regardless. We've been saying you have to allow breeds known as dangerous on my property if documents state it as service or companion. Well, not documents do not come from a medical professional but from the internet. In real practice, your incomplete parameters are not logical. You're absolutely right, Roy. You know, the piece that comes out of the guidance is that while you and I may consider a certain breed to be inherently dangerous, like a pit bull or a Rottweiler or whatever, the guidance won't allow you to use that as a rationale. It's about the specific animal itself, not the breed. And as to liability, the variations of state law, of course, will be, some owners will be liable for these things and some will not. So I agree that the parameters are broad enough that it does cause some concern. That's why we're having this conversation. I wholeheartedly agree with you. Okay, from Rich, this question: you're telling me that a tenant can request to keep their horse in my rental condo and I cannot deny that?
Well, actually, mini horses can be considered a service animal or a companion animal. They have regulations on mini horses, so that is technically accurate. As long as the tenant has a disability and there is a disability-related need for that mini horse.
Now, if someone, say in Kentucky, had American Pharaoh come to their apartment community and the person wanted to keep in their apartment or their condo, would that fall into the undue burden or safety issue, perhaps?
Yes, perhaps. If it was a full-size horse in someone's apartment, you could definitely make the case for health and safety or under one of the limited exceptions for denying that request.
This one from Kisia, I hope I pronounced that correctly. If a community does not subsection 8, what is the best way to say it besides no section 8? Well, assuming you're in a community that allows you to decline a resident based on the fact that you don't accept Section 8 vouchers, I would probably consult an attorney on specific language, because this is something that's going to be public facing, and you always want to talk to somebody about the best way to phrase that. But the simple answer, if someone comes in and says they're using a voucher, you can, by federal law, as long as you're not in an area that does not allow you to do this, just say that you don't accept Section 8 vouchers. Pretty straightforward. But again, if you're going to be publishing something or posting something, you definitely want to talk to your attorney about that. Excuse me. Richard has a question: is acceptance of Section 8 mandatory now in California or Los Angeles? The state law in California does not have source of income protection for Section 8 itself. It has source of income protection, but Section 8 is not part of that.
It specifically excludes Section 8 in case law. It excludes Section 8 at the state level.
But the local level is much different. As I mentioned, 3 different communities in my presentation that do have source of income protection that does include some variation of Section 8. And Santa Monica is one that we discussed that was just recently imposed this. I don't believe it's imposed in Los Angeles broadly, but I could go back and look at that. Do service animals or emotional support animals have to be licensed?
No, they do not need to be licensed.
What if someone continually calls the police because they're scared of the animal, but the animal isn't really harmful? This is from Sandra.
I would say that you can request information on the animal. If there are repeated police calls and calls to animal control about the animal, there is a chance that you could make the health and safety argument, but I would consult a local attorney, especially if the animal hasn't been aggressive or anything, but that there have just been complaints because the next door neighbor doesn't like the animal.
This question from Nadia: if my property does not accept vouchers, but a current resident then qualifies for Section 8 and needs to start paying by voucher, do we have to accept this payment? Again, if you're assuming you're in a community that does not have source of income protection for Section 8, I do not believe you have to do that, but I want to research that question out because there may be a specific way you have to handle it. But again, if you're allowed to not accept vouchers, then you don't have to accept vouchers, whether they're a new tenant or an existing one. But I want to research that and get back with you. From Agnes: can't raise security deposit because you'll have to change carpet if tenant moves because they had a dog. Do you take it out of the regular security deposit?
Yes, if there are damages from a companion animal, assistance animal, that must come out of their regular security deposit. You cannot assess an additional fee for that animal because it is not a pet.
From Christy: what if the companion animal shows aggression during the initial visit that another person would be denied for exhibiting? I'm assuming Christy's saying if I show up with my companion animal that shows aggression to another person, because it's a companion animal, am I limited in what I can do with that?
I think that makes a good case for the health and safety argument. If you witnessed aggression, if you yourself witnessed aggression of that particular animal, and again, it is a case-by-case basis. You need to do an individual assessment on that animal, and you could potentially make a good case if you've seen that particular animal show aggression.
This is from Nanette. She wanted to make sure this is correct. At this time in Texas, with the exception of Austin, owners do not have to accept Section 8. Actually, that's not correct, Nanette. Even in Austin, you don't have to accept Section 8. The state legislation in Texas not only preempted any other locality from instituting a source of income protection ordinance that included Section 8, but it also overturned the one that existed in Austin. The one exception that was in that legislation was for veterans rental assistance, the VASH program. So you're not allowed to decline a veteran that comes to your property in Texas if they have a veterans rental assistance voucher. But otherwise, the Section 8 piece has been dealt with statewide, including in Austin. Are the service and companion animals subject to pet rent? This one from Sabrina.
Again, any assistance animal is not subject to pet rent because it is not a pet.
follow-up question from Nadia. As a follow-up to large ESAs on top floors that only allow small animals, will I still have to offer a top floor unit to a prospect with a large ESA, or will that only apply to current residents?
That's a good question.
Wouldn't that be a discrimination concern if you weren't showing a tenant available units based on the fact that they had an ESA?
Yes, I think I think that would technically be unreasonably limiting that person, not offering them that top floor unit if it was available.
Okay, that was all of our questions. Great questions. Really appreciate all the the inquiries, and this tells me that there are a lot of people out there dealing with this issue clearly here. So as Nicole said earlier, if you have feedback or experiences you can share with us, please do, so that we can learn from those and add that to our sort of body of knowledge we have on this issue. Trying to advance the slide or contact information. So this is perfect timing. This is the end of our webinar. As I said, this has been recorded. It'll be on AEX by the end of the week. If you want to recommend it to others who couldn't participate, you're going to get a survey from us asking you questions about A, the quality of the webinar, and B, some substance questions on both companion animals and source of income protection. Please fill that out and get it back to us. We really need that information. And if you want to contact Nicole or myself, go to the NAA website. You can find our contact information there under the staff listing. We'd be happy to answer any questions or provide you with some more information. And lo and behold, there is our contact information right there. Thank you, everybody, for participating. Have a great week.